On Tuesday, Nnamdi Kanu, leader of the Indigenous People of Biafra, appealed to the Abuja Division of the Appeal Court against a decision by the Abuja Federal High Court. The decision had refused his application challenging the court's jurisdiction to entertain his trial. Kanu, through his lead counsel, Abuja Nyako, filed a notice of appeal, arguing that Justice Nyako of the Federal High Court erred in her ruling. Nyako contended that the trial court only considered 1 out of 7 jurisdictional grounds raised in the preliminary objection, leading to a miscarriage of justice. He also argued that the trial court wrongly required evidence to pronounce on the arguments and ignored the fact that the respondent did not contradict or deny the affidavit evidence presented by Kanu. Nyako emphasized that the trial court erred by deeming Kanu's preliminary objection as an abuse of judicial process and striking it out. Yes, sir. We are having a back and forth between the leader of the IPOB and the Federal High Court under Justice Nyako. And he has moved his trial to the appeal court for interpretation of Nyako's ruling. What's your stance concerning the case at hand?
Procedurally and legal-wise, it is the right of Nnamdi Kanu to appeal against a ruling of the court that is dissatisfied. Yeah. So exercising that right, I will not see it contrary to, I will not say anything contrary to it. But last week also, there was this news that came that the High Court, Federal High Court judge asked parties to explore amicable settlement.
Exactly.
And the leader of the group, being the one standing trial, has graciously agreed to, consented to that suggestion given by my Lord Honorable Justice Nyako. And so if I were to be a member of that team, exploring this other avenue will go somehow contrary to the intentions of that amicable exploration of settlement. So I do not see the need why the learned senior counsel, Nyako, will be pursuing this. It is within the right, but you must put to bear what is before us. We are looking for how we can solve the matter politically, using political grounds, not on legal grounds. Because if you insist on legal grounds, while you exercise your right, the Court of Appeal is not the final court. Assuming without considering that you succeed, the federal government can also appeal to the Supreme Court. It is the freedom of the person, Nnamdi Kanu, that should be paramount, and not having to score legal grounds or legal scores. So that should be his paramount reason. See how he has been in detention for such a long time. And what should be, if there is a political solution to the problem, that should be explored, because some of the rights cannot be exercised legally. It must come for what they call an ADRO, and that is what the judge has even given them. I think they should explore that window and leave the legalese that comes around the trial, because they have been on that for a number of times. And if I were to speak, the application, as rightly ruled, was an abuse of court process. You have previously brought this application before the court. The court dissatisfied and refused the application. You never appealed. You refiled the same application on the same grounds, the same prayers. So it was a clear abuse of court process. But like I said, it is right. Let's see what the three wise men upstairs will say at the end of the day. But if I were to advise, they should explore the political solution to it and not the legal rightness or wrongness, so to say.